So welcome to our part 2 session of Reclaiming the Best Interest Lens for Trans Children. Now you may remember from our part 1 session was sitting right here, Allison Williams from Justice for Children and Youth will be leading this session, and it is an interactive question. There is a presentation, but feel free to get your questions ready because there will be time for question and answer as well. So, all right. Take it away, Allison.
Thank you. Thanks, Logan. Yes, so welcome back, everyone. Thank you for coming back. I know it's getting to the end of a long conference, and so I appreciate you staying here till close to the bitter end with me. So I'm Allison Williams, and I am one of the staff lawyers at the Community Legal Clinic Justice for Children and Youth. So we are one of the province's 17 specialty legal clinics, meaning that the community that we serve is not geographically based, but our community is children and youth. Some of the other specialty legal clinics include, the HIV/AIDS legal clinic, there's an injured workers clinic. So many of us are in downtown Toronto. There's a co-op where we share space, but we have a provincial mandate. So we take calls from across the province of Ontario. We may be a good referral source for you. I know someone earlier was talking about representing primarily parents. If you have young people who are children of your clients that you think would benefit from having their own independent legal advice, we can be a good source, a referral source for you. Just to go briefly a little bit on the services that we provide, I mentioned we do summary advice on the telephone across the province. We also are very engaged in a lot of public legal education. So we'll do presentations to young people, to adults and others that serve children about children's rights. And then we also do direct client representation. Often our clients come to us through the calls that we get in, but we reserve our direct client representation for the most complex cases. So young people that often have multiple intersecting legal issues. So just to give you an example, a classic client of ours might be a young person where they're getting bullied at school, they react in a really intense way, they end up getting charged, they're subject to school discipline, and then we find out that maybe the incident was due to issues that they were experiencing at school due to their gender identity or something like that. Then we're very well positioned to try to address all of the legal issues. So I also just wanted to take a minute to draw your attention to our website, which is a really excellent resource for children and young people, and then also people that serve children and young people. We have our legal wiki, which has a lot of public legal information. So I encourage you to check it out at some point. So I just wanted to take a moment to talk a little bit about the way that we do our work at Justice for Children and Youth. So Tammy mentioned a few times about how, as a representative of MAG, she's distinctly not political. Our clinic, while we get our core funding from Legal Aid Ontario, we are a nonprofit. We have a board of directors, so we are independent. We are a child rights organization, so in many ways we are distinctly political. Our work is grounded in a child rights serving perspective. And when I'm talking about children's rights, I just like to ensure that people understand what I'm talking about is children as an equity deserving group who have experienced historical, legal, social, and political marginalization and exclusion. And so as a result, children as an equity deserving group, they have legal entitlements to enhanced state protection and interventions when circumstances warrant. And Tammy mentioned in her presentation, the UN Convention on the Rights of the Child, the best interests of the child principle. These are all things that have been incorporated by reference into our domestic law. So children are as an equity deserving group. The other thing that we encounter a lot is the question of, okay, well, what about parents' rights? And I think that it's important to understand that parents are not, their rights are not derived from their status as an equity deserving group, right? So while parents have responsibilities, and I think that, certainly, they have an important role, they don't have rights in the same way that children have rights. And so I just have included, a case from the Supreme Court of Canada that sort of teases out that distinction a little bit. So, and again, I think when we're talking about children's rights, there's often a lot of worry and concern about children as vulnerable and, subject to influence. And I think when we're talking about parents' rights, I think that's a lot of what we're talking about is parents concerned that people at school, other adults, other people that have access to their children as sort of, having the ability to sort of influence their children in an unhealthy or helpful way, and trying to ensure that their ideological views are guiding their children as sort of an extension of themselves. As we talk a lot about how some parents really treat children as chattel or children as property or something that they have control over. And I think that it's really important to remember that, especially as children age, there are again, it's recognized in law that as children age, they have increasing agency over themselves, and their views and preferences will become increasingly determinative as their maturity increases, and also that there's a recognition that that respecting those views and preferences are in fact in the best interests of the child. And this exists alongside the evolving capacity of children. We're going to, as children's capacity evolves, give them increasing agency over their own lives and decisions. So yes, I mentioned already the UN Convention on the Rights of the Child, and I think that this convention really guides our work. But I think that sometimes, especially when we're really in the weeds of the law that we practice, domestic law, we kind of forget that the UNCRC can be a really excellent tool, and case law that discusses or incorporates the UNCRC can be a really important basic first principle to refer back to in your advocacy for children and youth. And here I've just discussed a little bit about where the best interest of the child principle in the UNCRC has been incorporated into domestic law. A clear adoption of the principle is found in the Supreme Court of Canada's decision Canthasamy, where the best interest of the child principle is confirmed. Okay, so I wanted to speak a little bit and maybe talk a little bit to you about, again, some of the typical Justice for Children and Youth clients that we serve. So I guess I would just ask here, does anyone in the room know at what age can a young person withdraw from parental control in Ontario? I think I hear someone whispering it. Does someone want to try yelling it out loud? At the back? Yes, 16, okay? So we get a lot of calls from youth in this age range, 15, 16, 17, who are experiencing challenges at home. I think echoing some of Tammy's points, anecdotally, we're seeing a lot more calls from trans youth who are experiencing rejection by their families, or maybe if not outright rejection, just are not being affirmed by their families, and as a result, they're sort of seeking to set out on their own and to chart their own course. And in Ontario, if you want to withdraw from parental control, you don't require a court order to do that. So, it can be, when you're giving this advice to young people, it can feel, I think, pretty shocking and strange for them, where they're sort of saying, what? There's nothing that I need to do, I don't need to get a court order, but how do I assert this right? So, one of the things that our clinic does assist with is, writing letters for young people so that these rights can be recognized in various contexts, which kind of leads to my next question. I'm just curious if anyone has any ideas as to where young people who are attempting to withdraw from parental control, what sort of barriers they might experience or where they might encounter barriers. Sure, at the back again?
Pretty much any time they're trying to sign any contracts, say a lease, we'd like to be able to get housing for themselves. The landlord, they don't know most landlords who don't want the signature for the 16-year-old.
Yeah, housing is one area. Anyone else? Yeah?
Waivers and indemnities in sports.
Okay, waivers and indemnities in sports. Any other ideas or thoughts?
Actually, let's just get anybody who has input. Let's make sure you get the microphone because this is all being recorded. So, sorry, who had their hand up on this one?
I just said waivers and indemnities.
Oh, right. It's like the idea that contracts may not be recognized by third-party collaterals.
How about anything financial?
Yeah, financial.
And I had indicated if they're under 18, they can't contract, kind of back to trying to find housing.
Yeah. So one of the things, you can contract for necessities, right? So that's how we often get around things like housing. And so there's an exception in the Human Rights Code to permit people under the age of 18 to sign leases. You can't discriminate. You can discriminate based on age in other areas, but not in housing, because it's a necessity, right? Any other ideas? Okay, so I can share a few more. One of the areas where a lot of young people face barriers is in the school context. So when you turn 16 and you withdraw from parental control, for example, a young person can go and say, I don't want the school to be communicating with my parents. I want my report card to come to me. I want to be able to, the phone calls that come home when I'm absent, I want them to go to me and not to my parents. And I think that many school administrators aren't aware that young people at 16 have the ability to do that. So sometimes we're just writing letters confirming a young person's right to withdraw from parental control and how it works in conjunction with the Education Act. I think a lot of the work that we end up doing for these clients, though, will also be just some of where the legal and the social bits intersect. So Tammy mentioned earlier about advocacy to children's aid societies, and so that's something that we also do work with, both helping young people approach the children's aid societies to request voluntary services and to help them to kind of frame the issue. It's probably not surprising to you that sometimes 16 and 17-year-olds need a little bit of support in articulating how their circumstances might lend themselves for the young person to be a child who's in need of protection. And then so other options are, assisting them to apply for Ontario Works. So 16 and 17-year-olds can apply on their own for Ontario Works if there's special circumstances. So we'll assist young people applying for Ontario Works, or if their applications are refused, we would assist them in appealing that decision. Or other areas we give advice on, if a young person has left home and their parents are refusing to return their belongings or to give them their identification, then we might support them in writing a demand letter to get those sorts of, to get their belongings back. The recourse being, a small claims court or something like that. Also, young people who have withdrawn from parental control, if they've done so involuntarily, then they may be eligible for child support. So we might also be assisting them in bringing a child support application. So that's kind of just a quick overview of the issues that impact generally children that are leaving home. But I guess I was curious if anyone had any thoughts about how might these legal barriers be different or exacerbated for trans youth. Any thoughts?
They may have difficulties accessing identification that is aligned with their preferences, and having to prove to an adult that you're 16 so you can sign on your own behalf in certain circumstances, and you don't go necessarily by the name that you were identified with at birth, and I think just anytime trans youth have to interact with any kind of formalized institution, they're immediately at a disadvantage because they have to take more steps just to access the very basic services and prove themselves over and over and over again. And if they're in a particularly vulnerable situation, it might not be something that their mental health or patience or environment allows for.
Yeah, for sure.
Jen?
I'm also thinking that if someone's not, a trans youth is not being supported in the process, in the transition, and maybe it's someone saying, oh, you're just going through a phase, or you're just experiencing something like that, to add the issue of leaving home, someone might also not be supported, thinking, you don't know what you're doing, you're jumping into things, slow it down, and they might not get the support even though it's what they really want.
Yeah, for sure. For sure. Some great points. And I think, another area is healthcare, right? So maybe I'll just put a pin in that for a minute because I think I have a couple more slides on that. But yes, all great points. So just circling back a little bit to the point about identification and name changes. So one of I think Tammy mentioned referring to organizations that will assist with name changes. That this is something that Justice for Children and Youth has been engaged in a long time. And this was a case, KAB, that we were involved in that sort of set the precedent that young people who have withdrawn from parental control don't require parental consent if they're under 18. So generally speaking, if someone is under 18, anyone who has custody over them would be required to get parental consent in a name change. But because young people who have withdrawn from parental control have essentially taken over the incidence of custody as they pertain to themselves, that parental consent is not required. Typically what we do when we're assisting young people in this situation is we'll probably have them swear a statutory declaration stating that they have withdrawn from parental control, so that there is some document. Again, this is where it can be a little bit tricky that a court order or something is not required to withdraw from parental control, because a young person doesn't necessarily then have any sort of physical document to rely upon. Yes, so going to healthcare, does anyone here know at what age can a young person make their own healthcare decisions in Ontario? 12. Someone says 12. What is? Yes. So Karen at the back got the trick question here. Woohoo! sat on a hospital board. Okay, she's being modest over there. But yeah, so in Ontario, there's a presumption of capacity, okay? And it's left to individual health care providers to sort of make the assessment whether, someone has the capacity to make a healthcare decision, and that, involves ensuring that the patient understands understands what the procedure is and appreciates the consequences of the health care. And so again, I think in the context of trans youth, this is something that also really worries a lot of people, right? This idea that young people are vulnerable to to being influenced by their peers or others to make healthcare decisions that will have impacts later into life. And so I wanted to sort of to make the point, and I know if I've heard Tammy speak on this topic before, and speaking about her own personal experiences, and I think I would want to sort of maybe dispel the notion that it's easy for young people who want to access this type of gender-affirming care to just go and do it. There's many barriers, there's many steps to accessing gender-affirming care, and what's really important is that Canadian healthcare providers I've included here, they broadly follow special guidelines and standards. And I've also included an article. I hope the slides are distributed, or if they aren't, people are welcome to reach out to Tammy and I, and we'd be happy to share them, because we did include some resources here. This is a newspaper article talking about how gender-affirming healthcare works for kids in Canada. And it's a process. Like Tammy said, it's not something that happens immediately, but and often where parents are and can be included, it's something that's often encouraged. Okay, and then I'm just conscious of the time, but I did want to speak a little bit about schools, and I think schools are also a place where gender identity and trans kids have kind of been increasingly politicized. Their identity has been increasingly politicized. I think that Ontario, as compared to the other provinces, are some of the most welcoming schools and school boards for gender diverse youth. So currently in Ontario, policies are issued by individual school boards, and each board has to develop policy in accordance with human rights legislation. And boards have a duty to uphold the Human Rights Code as it relates to gender identity and gender expression, which is protected in the Ontario Human Rights Code. And I can just tell you from what I've seen on the ground in Ontario, I think, kids still, face challenges and difficulties, but I do think that it's better for kids in Ontario than in other provinces. So I just highlighted in this slide here, our clinic, Justice for Children and Youth, I mentioned earlier, we are involved in law reform work and also test case litigation. And we actually recently intervened in a case at the Saskatchewan Court of Appeal. I'm sure many of you are familiar with it. It's the notwithstanding clause case where the government of Saskatchewan brought legislation which would require teachers and school boards to misgender or require children to come out in order to use their pronouns in school. By out, I mean the requirement for parental consent would sort of perhaps force them out earlier than they otherwise would be. And so that, stay tuned. Justice for Children and Youth, we intervened in that case. It's still before the courts as to what will happen with that legislation. But again, I've included a link here if people are curious to learn a little bit more about what's going on in Saskatchewan. Good news out of New Brunswick from our perspective. New Brunswick was another place where there was discussion about policies in the same realm, but the new premier there has indicated that they're going to walk back policy, which prevents school staff from using a chosen name and pronoun unless they get parental consent if the child is under 16. But as recently as last week, Alberta has now tabled legislation that's quite similar to the legislation in Saskatchewan, but notably, they did not use the notwithstanding clause, which I think leaves their legislation ripe for challenge as well. And then I also just wanted to talk a little bit about trans youth in the YCJA context. So I think, Tammy at the beginning of her presentation did a really excellent job, I think, of setting some context around the special and unique challenges and vulnerabilities of trans youth. And unfortunately, I think that as a result, of their marginalization, we do tend to see, I would say, an overrepresentation of trans youth as accused and complainants. And I was just curious, the courts themselves have done a lot of work to try to make courts more welcoming place for gender diverse people. I've included here just a screenshot of the notice to the profession and public at the Ontario Court of Justice about pronouns and pronoun use, and I know there's similar policies at the Superior Court of Justice. But I'm just curious if anyone in the room here has any those practicing criminal law, if they have any experience with the treatment of trans youth or accused people and complainants, if they see these sorts of policies being widely adopted or not.
I've had both clients and complainants, and everybody in the court system has used the name that they wish. We refer to them by the gender that they have told us that they wish to be referred to as, and it's been very supportive regardless of who it is appearing in front of the court.
That's great.
So,
anyone else have any
the
comments?
police, on the other hand, not so much.
Yeah.
Hi, Shanoa from Kenora. I have one client who our district probably knows. She was initially a male, and the jail has continuously decided that when she's arrested that she goes to the male side, and she's made it very clear, and everyone is very aware that she identifies as a female, and that's still an ongoing struggle, which is pretty pathetic in my view.
In my experience, the court has been willing to change the name on the information, and the example I'm thinking of, the person's a repeat offender, so the police keep laying the new informations using the dead name, even though we've gone to the effort to put various other informations into the name they want to be identified that fits their gender.
Yeah. Interesting. Anyone else?
Oh, sorry, I'll just add. But they'll say, well, we have to use the legal name, but they don't always use everyone's legal names. So
I've had the experience of, I think there's been some people who are sort of involved in alternative legal systems in their own mind, the sovereign citizens and people like this. We get a few of them in our community, and they want to be identified by names that are not their legal names, not for gender reasons, but for other reasons. They'll say, I want to be the person known as this, because they're asserting that the legal system doesn't apply to them and saying, so I think for that reason, in our courts, they're sometimes cautious about people who say, I want to use a different name than my actual name or my registered name. And also I've seen more requests for ID because people are witnesses and others are told to bring ID when they come to court. The other thing that I've run into is you sometimes get a person who is biologically female but identifies as male, dresses male and presents as male and so on. But when they're charged with a criminal offense, they do not want to go to a male prison. And so I think that the correction system people are sort of saying, looking for, I don't know they're looking for direction, but they certainly would see it as very wrong to send a biologically female person into a male jail. And I've had clients who are female prisoners who say they do not want men or biological males in the jail with them. So it's a hard issue.
Yeah.
It's a hard issue for the accused.
Thank you.
10 seconds, Terry.
Thank you. If I could pick up right at that point,
Yeah.
in my jurisdiction, we add the name AKA, also known as, and put the other name as
Yeah.
well, so both are there.
Yeah.
But on the jail system, that was what I wanted to address. I had someone who was male by birth, but was female, and was addressed very well in the jail system until they were transferred out of our jurisdiction.
Yeah.
And then ultimately was treated so poorly that they ended up committing suicide in the jail. So it's a very, very troubling issue, and no matter how much I addressed it with the corrections that you, like going into court, he, no, she, you know, and that sort of thing, and then ultimately just completely demoralized.
Yeah.
And that's where it's a tough issue. We need to bring corrections, educate, and have sensitivity training there towards trans individuals. Thank you.
Yeah.
Just a quick comment, on both levels, family or child protection and criminal. I've experienced on both levels. From the criminal court perspective, getting the name changed was a challenge on the information. Nonetheless, despite the fact that court endorsed it and requested the administration change the name, they just continue to put in the birth name rather than the individual's chosen name and identity. So, but nonetheless, it was accomplished after about 4 or 5 appearances. On the child protection sphere, VISA or working with CES, it's always been a good experience where there was no challenges at all.
Yeah. So it's very, very interesting to hear your experiences. Maybe we need to start making complaints to I know if the name has changed. It used to be the Ontario Independent Police Review Directorate. I know they've changed their name recently, and I don't have it in my mind, but maybe for law enforcement or others, maybe the move is to be making complaints about specific officers. I mean, I think the point that you raised about spaces for people to feel safe, so for people who are in custody. I mean, I think for a long time, I think we thought it was impossible to deal with the bathrooms issue, the washrooms issue, but I think that as a society, we've really adjusted. I went back to my old high school recently, and they've transitioned to single stall washrooms for all high school students. I think at one time we would have thought that's impossible. I mean, I do hear from the administration that comes with its own challenges, but I mean, I think that there probably is a solution with some resources that could be found for some of these issues. And I just think that it's what's really heartening is that we have groups of people that are thinking about these issues, not just sort of as trans people specific issues, but issues that we all can and should be engaging with as people that have an interest in the promotion of justice. So I think I'll just leave you with that thought. Thank you very much for your attention. Thank you very much for your engagement in this issue, and thank you for having me. Thank you for staying in.